Every Tuesday, we bring in immigration updates from Reddy Neumann PC live here from Houston, Texas. Along with me is my business partner, Stephen Brown. Stephen, what do we have today to discuss?
Yeah, we got a couple of good topics. We got the visa bulletin out yesterday for January 2024. We saw some good movement on EB1, EB2, and EB3, not as much for India. Uh, we're going to talk about the Dropbox eligibility forecast. So we know that it's been expanded throughout COVID. That expansion ends December 31st. So what are we expecting? And then we're going to talk about this issue that we've been seeing at the consulates where there's been an F1 rejection and someone can't get a new visa appointment.
Now, Stephen, we see that there's a movement, almost like 3+ years of movement in EB1. Do you expect going forward in this financial year as we go on?
I think EB1 we might see a little bit of movement next quarter as well. For whatever reason they decide they're going to move dates each quarter. I could see us getting a little bit of movement on EB1 India moving forward. I don't anticipate much for EB2 and EB3, but EB1 maybe a little bit more. Just going to depend. With the administration's focus on STEM, we're seeing more EB1 filings and approvals that are porting priority dates. So we're just going to have to see how things come about.
Okay, so what do we do, people whose priority date is final action date is current? Stephen, what if you're telling that they may move forward? Who knows? They may move backward too. What is the best option for them to do it? Because if it moves backward, then I'm stuck here for a while.
Yeah, I mean, we've seen since 2020, the visa bulletin has been a roller coaster, right? It goes up, it goes down, it goes forward, it goes backwards. And I think it's, time if your visa, if your final action date is current, get off the ride, get off the roller coaster, do whatever you can to secure. So you do whatever you can. Do whether it's a service request with the agency, an expedite request, contacting your congressman, or if it's been pending a long time, sue on the delay of your 485. We've been doing a number of those cases. For the most part, we've seen good success on them when they're meeting certain criteria of lasting, of being pending for at least a year. The EB1 cases, Rahul, I think we could be a little bit more aggressive on. I mean, Congress put them in the first preference category for a reason, right? They're pretty important. So I think, do whatever you can, whether it's service requests or talking to your congressman or suing on the delay. Get your green card as soon as your final action date becomes current. We don't want to see people getting stuck with the retrogression issue like they did last fiscal year.
Most probably, we are not expecting any priority dates movement advance in EB2 and EB3. Stephen, is that right?
Yeah, I mean, we know that they've already come out and said, hey, we've already got enough 485s to handle it. I think it was for some of the data we had in litigation for the next 10 years. So I don't anticipate much movement, especially for the filing date. Maybe we'll see a little bit of movement on final action date, steadily like a turtle on EB2 and EB3, but certainly not the filing.
Stephen, when I want to move to the next topic, though, at this point of time, almost everybody is eligible for the Dropbox appointment. Those people who are on student visa, who want to convert into H1B, they could go. They're eligible for the Dropbox. Those people whose passport H1B visa has expired a long time ago, they're eligible for the Dropbox. Those people who came in H4 visa and they want to apply for the H1B, they can go to India, go for the Dropbox visa eligibility. But starting on January 1st, though, all the rules are changing back to the old rules pre-COVID, where Dropbox is only eligible if you had a H1B visa before and you're going for H1B visa again, and that your previous H1B visa must not have expired more than 1 year ago. So what do we do right now? I mean, do you think so? There's this the old rules are going to come into picture on January 1st, or would they extend the current rules right now going forward?
I think I'm hopeful that they continue to extend it. There's been a lot of talk through various organizations about encouraging Department of State to do it. I know when I was at a conference this summer, Department of State said they were looking into trying to expand it, knowing that the current Dropbox expansion expires on December 31st. I think, to be honest with you, I think the consulates have liked it. They can kind of work better with their man hours when they aren't having to do as many interviews. So I'm hopeful that here right at the end of the year, we're going to get a nice gift and get that extended, because it's been helpful for a lot of people, I think, getting the waiver, the interview waived with Dropbox.
So right now, Stephen, as it stands today, starting from January 1st of 2024, if I came on H4 visa, if I'm going for a H1B stamping, I am not eligible for the Dropbox. Is that right?
There was always a debate because H is still technically the same classification, but I think they weren't allowing the Dropbox for
Previously,
H.
they were not allowing. Previously, they
Yeah.
were not allowing H4s to apply for H1B. They were only allowing if the H1B extensions were there. So going
Yes.
forward, until there is a change in the administration or they issue any new notification, those people who are moving from H4 to H1 and they never got their H1B stamped in India, they still have to go through the manual interview. And those people who are moving from F1 to H1, the same scenario, you will have to go through the manual interview process though. However, as Stephen has pointed out, there is a likelihood chance that they may extend this offer that we have until December 31st because it will ease the administrative pressure on the passport stamping. It will ease the delays that are getting caused in the appointment, especially in India, which is one of the biggest places to get a visa. More non-immigrant visas are issued in India than any other country in the world right now. So they may extend it, but please keep tuned to our YouTube channel. We will update you if there is any updates on that. But as of now, as it stands today, from January 1st onwards, if you're moving from H4 to H1 or from F1 to H1, you will have to go through the interview process. You will not be eligible for the Dropbox. All right.
Rahul,
Mhm.
yeah, no, definitely. I mean, that's how it was prior to COVID. Right now, we haven't seen any real indication other than hopeful that it can go back to, continue with the same trend it is now.
Uh, Stephen, we have seen that the number of student visas issued in India is the highest right now. India surpassed China in 2023. And we are expecting more non-immigrant student visas to be given in India. However, there are some people who get rejected in the student visa. Previously, Stephen, people used to just go ahead and reapply for the visa stamping. Let's say, for example, I got an admission in University of Texas at Austin, and then I applied for the
It's a
visa. I
fraud
got my
school
visa.
anyway.
I'm sorry?
It's a fake school anyway.
Well, you're from Texas A&M. I don't like you anyway. Um, Coming to the point that if they don't get the visa stamping in Texas, Austin, and they want to go to the visa stamping again, they used to make an appointment and then used to go for a visa appointment. But we are noticing that the online system, Stephen, is not allowing to make an appointment one more time if their visa gets rejected. Does that mean that they can never make a visa appointment? Or what's the process for them if their visa gets rejected because of the immigrant intent and they want to go again for the student visa, Stephen?
Yeah,
I'm
so
assuming that this time it's for a university that you like the most, Texas A&M.
right, they'll go to a good school like Texas A&M.
Yeah.
No, so 214B immigrant intent is one of the most common reasons for denial for B visas and F1. You can't show proper ties to your home country or that you're going to come back, so they deny it. And if you look at the Foreign Affairs Manual, Department of State is very clear. That happens, and it doesn't carry on with you for the rest of your life like maybe a fraud finding might. But that immigrant intent just denies that visa, and you can go apply again. It doesn't carry over to the next visa appointment. Right now, what I think we're seeing is a technical glitch. Remember, this is a new system, right? They opened up this new system for visas in India, especially in India, this year, and are working out some of the kinks with it. My recommendation would be to contact the consulate or contact if there's a customer support line and reach out to them about it. If it does continue it is a trend. I think it's worth it's something that we want to keep an eye on as a firm. I don't know how much litigation would help or reaching out and maybe trying to reach out to Department of State on this, but it's not something that I think is going to impact you long term, right? It's not even supposed to. The Foreign Affairs Manual is very clear about the immigrant intent findings, so I don't. It shouldn't follow you. It just maybe it's a technical glitch right now.
Most probably, we're expecting that to be cleared soon. If not, what do they do? Should they contact the consulate to see for appointment
I,
manually?
I would, yeah, I would contact the consulate, try to explain it. Like I said, there is the Foreign Affairs Manual for Department of State is very clear that the Immigrant Intent 214B findings aren't supposed to follow you to future cases. Maybe it makes it harder because you got to overcome that hill, but you should be prevented. You should not be prevented from seeking a visa again.
Okay, well, let's go to the Q&As, Stephen.
Yeah, so trying to find, there's a good one here. Third lottery is a question we have here, and it's a question I wanted to address because it's something we are getting constantly. We don't know. USCIS has not announced that they have received enough petitions to fill the lottery, nor have they announced a third lottery. We looked, Emily and I looked at it last week. We kind of expected the end of last week based off of prior years to announce if it was full. Based off of prior years, I expected it mid-November if we were going to have a third round. We don't know yet. And unfortunately, everybody, we won't know until they start sending selection notices or make the announcement. So we just got to sit back, buckle up, and wait on that one.
My priority date is 2023. Perm is in process, rest of the world. Will I be able to file 485 in August of 2024 based on the trade? Yeah, there is a good chance that you may be able to file the 485, assuming your perm and I-140 of your perm is approved. You should be able to, based on how the readings are right now. But things can change very quickly on that. I will always have an alternative plan just in case of any chance the priority date doesn't become current. What are the alternative things that I would do? I would have an action plan of it before, I would consider those alternative options if the priority date doesn't move to be current.
A question from YouTube. My H1B is valid till May 2025. I changed status to H4 EAD. Can my employer just use my EAD for I-9 without withdrawing the H1? Is the employer obligated to withdraw the H1? They are not obligated to withdraw the H1 if they didn't terminate you. I will tell you, a lot of employers think go in their best practice to withdraw it so that way they are not liable for any wages, just to be 100% safe with the H1B rules. But they're not obligated to.
One second. Can a perm and I-140 be filed for a different location other than the location filed for the H1B? Absolutely. That can be filed. It doesn't have to be the same location. This question comes from SK from YouTube. Did the EB1 dates move because of the 25K spillover? Could be. It could be that the 25K spillover could be one of the reasons why the EB1 dates are moved. But at the same time, imagine that the priority date for 2000 was 2017, the final action date. We don't see any of those applicants between 2017 and 2020 because most probably the priority date becomes current in October of 2020. So not many people were present in the priority date between 2017 and 2020. So that's another reason why I think so the priority date or EB1 has moved from 2017 to 2020. We may not be expecting a drastic movement from here, but it also depends on the rest of the world though. If the rest of the world EB1 is not used, those green cards will be given to Indian nationals who have been backlogged. So as the year progresses, which starts from October 1st, as the year progresses, the USCIS will be able to know how much is the demand for the rest of the world, and based on that, they can keep on allocating to the India, and that's where in this quarter you see that there is a movement in this in the second quarter of the year. The first quarter is starting in October 1st. The financial year starts at October 1st.
Question for Prashant on YouTube. Can I still apply H4 EAD for my wife after changing jobs and my former employer revokes my I-140? So this is going to depend on when the kind of the timing of the I-140 revocation. If the I-140 was approved and it's been approved for more than 180 days and they've withdrawn it now, then yes, absolutely. At that point, you get all the benefits of the I-140 other than being able to adjust status. You can do the 6-year, the extensions, you can do the EAD, as long as it's been approved for more than 180 days.
Question that comes out from me is how to move from adjustment of status EAD to H1B. What's the technical way? Assuming that you already used the adjustment of status EAD and you now want to move to H1B, the best way to move, and I think so that's the only way that I can think about to move, is to get the H1B approval, go outside the country, get the H1B stamped in the passport, and come back on H1B. That's the best way of moving from adjustment of status EAD. Now, only if you have used the adjustment of status EAD. If you have not used the adjustment of status EAD, you came back in advance parole, your H1B is still valid. Technically, if you have not used the EAD, you can still extend the H1B within the United States. But assuming that you let your H1B expire and you started using the EAD, then the best way to get back to the H1B is to go outside the country and get the stamping and come back.
And if the H1B is not facially expired, it's still, the I-797 still shows validity. We've had success doing an amendment plus extension. There's an old memo, the Cronin memo, I think, gosh, I can't remember what year it was, that allowed you to do that. And even though that memo shouldn't be used in practice, it is. And you can extend your H1B even if you entered on EAD and AP.
Okay, that's a good
question question here from YouTube. Any update on the HPI recommendation to the White House on the EADs for I-140s? No. I just wanted to kind of explain that group and what they do and how this works. They are there to make recommendations for their group, the Asians and Hawaiian nationals here in the U.S. to on how the administration can better serve them. This is a recommendation. That's all it is. It's now up to the president and DHS to put that forward in a regulation or enact it. So it's up to them to do it, but there's no binding power of that organization.
What is the timings for the prevailing wage and perm processing timings right now? What do you expect going forward? This question is coming from UK, from YouTube. Is NIW is a good option? What are the approval rates? Well, in national interest waiver depends on your qualification and whether you meet the requirement. And if you meet the requirement, definitely it will. So we have to look into requirements for the national interest waiver. Prevailing wage determination right now is about 8.5 months right now. And perm application, if you're filed, it's 12 months and 15 days. That's approximate time for you to get the labor approved since the time of filing the perm application. Srikanth is asking, is there any fees if you request for I-140 petition to Freedom of Information Act? The answer is no. Even though when you file a Freedom of Information, they say that they may charge you some money, we have never seen USCIS coming back and charging money. And even if they do, okay, guys, it's only $20, $30, which I don't think so you mind paying that money.
This question from YouTube. I'm on Green Card EAD and working with my sponsor employer and want to take a second job on 1099 and keep the first job. Is that okay? Yeah. The Green Card EAD is an unrestricted right to work. I mean, you can work 1 job, 2 jobs, 10 jobs. You can work at the CVS next door to our office. You can go work at NASA. As long as you're doing legal work, it's okay. I do recommend you have something in your field so you can continue to get sponsored at least. But outside of that, it's pretty much up for grabs.
I worked in India for 16 months, then came to USA on L1B in 2030. Subsequently, company filed a H1B in POM or EB2. My priority date is 2000. Can I apply for EB1C now under functional manager category? This question is coming for Arindam. assuming that since the time you came into United States to right now, you're still working for the same company for which you came back on L1B, technically speaking about you are eligible for filing the functional manager. Now, will the company do it? That's up to them. But yeah, you're still eligible technically. If you have worked for a different company, now you want to move to this company, though you may not be eligible. But since you're working since the time you came in 2013 to right now, 10 years for the same company, you are eligible for the functional manager EB1C if you're eligible for it.
Question from YouTube. H1B in master's cap is under processing, but I didn't submit a master's degree and my case is under processing, so will it be a problem? So if you got your master's degree prior to filing the petition, it won't be. You'll just get an RFE or notice of intent to deny, and you'll respond with the master's degree. If you did not complete your master's degree prior to filing the petition and it was selected in master's cap, you're going to have to withdraw the H1B because it's not going to get approved.
What is the current date for the family-based immigration petition? The family-based immigration petition, the final action date right now is actually for Indian nationals, it's 2019, November 2019. But the filing date is actually September 2023, which is just like 4 months down the line. And they're accepting the filing dates right now for the family-based immigration, which is backlogged by about 4 months right now.
Question on YouTube. I've applied EB2 and EB3 and got an interview on August 2022. Does USCIS consider my case in EB2 and EB3? I've seen it where they kind of will let you choose, but you should be being proactive and doing the transfer underlying basis. I will say in litigation, we have argued that the transfer of underlying basis is just a convenience for USCIS. That you're eligible under EB2 or EB3. So whichever is current, just give you a green card. That we don't care whether it's an EB2 or an EB3. Just give you a green card and let them figure it out. And we've been fine with that.
Dilip Kumar is asking a question, how do I determine the B1, B2 is still valid or not revoked? I've seen some of my friends' parents, visitors visa got revoked at the port of entry, had to return back to India. Good question, Dilip. If a person stayed in United States unlawfully for one single day, the passport visa becomes automatically invalid. For example, let's say your parents have a visiting visa to come into United States. They came in January 1st of 2023, and their visiting visa is valid until June 30th of 2023. If they stayed until July 1st, that means they stayed one day unlawfully in this country. That means that whatever their passport visa, typically the passport visa is valid for 10 years, the passport visa automatically becomes invalid though. So next time when they're trying to come back into the country, the USCIS or the CBP will come to know that this person has overstayed, that automatically their visa has been revoked, so they can't come into the United States. Now, under limited circumstances where if you file for an extension, let's say you filed it before June 30th, and let's say they left in July 30th, and by the time their B2 is not adjudicated, technically speaking about, they are not unlawfully present here from July 1st to July 30th because they have an extension pending. Since their extension is pending, their passport visa is not valid. So to determine that whether their passport visa is still valid or not, we need to determine if they stayed unlawfully in this country for at least one single day. And that's the reason why we see that some of the people who are coming in, the CBP will look into they violated the status and they will send them back to their home country. So before your parents come into the United States, make sure you determine they never stayed unlawfully in this country, not even for a single day. And if you have any doubt that they stayed in unlawfully, always check with an immigration lawyer before you have them embark in a journey of coming into the United States.
Yeah, and the reason you want to make sure you do that is the bar. If you enter in and the visa has been revoked by a matter of law because of the overstay, they could put them in expedited removal, which is going to come with a 5-year bar, and you want to avoid that. Question from YouTube: can you write a book, an article, and earn money while on H1B? You know, this actually popped up on Twitter this past weekend about whether you can do things like this, and David Beer from the Cato Institute was kind of saying you could, and you know, some attorneys were kind of going back and forth debating it. I don't think you can. I think the way U.S. immigration law is structured, it is restrictive unless you're given permission. And what I mean by that is you can't do something unless they give you permission. So you can't work unless given permission to do it. So on H1B, you're authorized to work for ABC Corp, and that's it. And writing a book, I think they would interpret as work if you're doing it for money. If you're doing it just for the fun of it, you know, we write articles here on our office. I don't get paid extra for those. That's fine if it's part of your job. But I think if you're going to go home and write the next murder mystery novel, I think that's going to be considered work.
If my forced H4 plus EAD change of status is pending with USCA, yes, she gets a job on H1B. Does she has to go to the consular processing, or can she get the H1B approval with a new employer and start working? If the H4 and EAD is pending, though, extension is pending, or even in the initial application is pending, though, you can apply for the change of status even though H4 is pending. USCIS is approving the H1B with the I-94 right now. We have seen, especially from March of 2023, we have seen them approving with the I-94 without any problem, in which your wife can actually convert into H4 to H1 while the H4 is pending. They will approve the H1B with the I-94, and your wife, once she receives the H1B with the I-94, can start working for the company on H1B.
Question from YouTube: can I use H1B case approved in 2015 to now do a transfer with a new company in 2024? It's going to depend. If you are considered what's counted, what is called counted against the cap, yes. How are you counted against the cap? Either that 2015 case was approved for a change of status and you worked at least one day on that H1B, or you got an H1B visa stamp. Yes, you can use it now. You know, as long as you haven't gone over your 6 years, you can use it with that new company here in 2024. But if you're not counted against the cap, you can't use it for the new company.
Sunjit Kumar is asking the question, whether EB1A for India will become current in 2024. No, I'm not expecting the EB1A totally to become current, though. At least not in the financial year of 2024, which ends in September 30th. I am not expecting, but you know, unless there is some miracles. I recently got. Go ahead.
Oh, go ahead, Rahul.
I recently got interviewed for both EB2 and EB3. I had to withdraw the EB3 application per officer. Will USCIS issue me EB3 if it becomes current? Both 485Js are approved after interview. Yeah, I mean, if your EB3 is current, what I will request the USCIS is, hey, look, I have an I-140 approval in EB3, and please give me the green card. I will request them. I have done it time and time again. When the USCIS has forced us to withdraw one of the application, we still went ahead and requested the USCIS to adjudicate it, and they have adjudicated the cases in EB3. Absolutely not a problem.
Naresh asked a good question on this topic. My H1B visa expired on August 2022. Booked a visa slot for Dropbox on February 2024. If the Dropbox isn't extended, does he have to go to an interview instead of Dropbox? I don't think so. The system is going to let you do Dropbox, and if it lets you do Dropbox, that's fine. It kind of asks those questions to get you there. I don't think they're going to make you do. Now, they can always call you in for an interview anyway, but I don't think you need to be concerned about, I got to go in for an interview instead.
Shubham Sharma has this question. My POM has been filed in November 2022. I've known people whose POM has been filed in December 2022 still got that approval. I would still wait for one more month before. We have still some cases that we filed in November that are still pending. I will wait for one more month before contacting the USCIS. Nag Kumar has this question. He has a travel plans to Bahama on a cruise ship. His H1B is valid until October 2025, but his passport is not stamped in the passport. Can he use the automatic revalidation to go to Bahamas and come back? The answer is clearly no. Now, for the H1Bs and H4s, the automatic revalidation is not valid for Bahamas. It is valid for the Mexico and Canada, but not to Bahamas, especially for the H1Bs and H4s.
One thing you may want to look into is that the and I haven't dug into the regulation all too much, but there is language that these closed loop cruises where you leave from one port and come into another are not considered a
That's
departure.
for student visa people, it's quite different,
Yeah.
Stephen. When it comes to
Oh yeah.
Bahamas and the Caribbean, the student visa people are a little bit different. But when it comes to H4 and H1B, I would still recommend to stay away.
Uh,
Can
question
I,
from
go ahead.
YouTube: can an H4 EAD person make money from YouTube? Absolutely. H4 EAD, you can do whatever you want as long as it's a legal business in the U.S. You can make money from YouTube, whatever you want to do.
Can I apply for H4 EAD for my wife without I140 approval letter, along with me H1B transfer to the new employer? Will the H4 EAD be valid even if the ex-employer revokes I140 after transfer? Assuming, Prashant, your I140 with ex-employer has been revoked after it's been approved for more than 180 days. Yes, absolutely. You can file the H1, H4 EAD together along with your H1B with a new employer. Even if the previous company has revoked your I-140, assuming it's been revoked after 180 days, your wife is still eligible for H4 plus EAD. You should file H1 and H4 and EAD together.
S. Roy asks, is I-130 still pending for 20 months at Texas Service Center? Shoot me an email, Stephen@rnlawgroup.com. Let's talk litigation on that. That's way too long. Vipin, same thing you're asking about. The 485 is showing case remains pending and the priority date is current. That we've been suing on those. Depending on how long your 485 has been pending, I don't think, for me personally, I'd rather take action than not take action. I'd rather sue than wait to make sure they mark my case right and get it adjudicated. I don't want, I don't think people should be risking the retrogression if it were to occur again like it did last year.
I have started working on EAD with second employer. My first employer is still under the impression that I'm an H1B wanted to extend. What will happen if they apply for H1B? Well, they are extending the H1Bs under the current circumstances. Nothing is going to happen. Arun, will EB2 India April 2000 priority date become current in the next couple of months? We don't know yet. We don't know yet. We have seen a couple of months movement, 2 months movement. Hopefully, so there will be a couple of more months movement in the next coming quarter, though. Hopefully so. But we cannot tell you clearly, though, if it's going to be movement or not.
Question from YouTube. I had cap gap until September 30th, and my H1B is still pending. Can I stay here until my results? I didn't opt for OPT and status discriminated. Yes, as long as you filed the change of status to H1B, you can continue to stay in the U.S. while it's pending.
Am I eligible for Dropbox? I'm moving from J1 to H1B. The appointment is in March of 2024. At least under the current rules, you don't look to be eligible for, but we don't know if they would extend the rules. Under the current rules, as of December, you are eligible. From January, you're not. But we don't know if they would continue with the old rules.
Question here. EB2, I accidentally answered no to the public charge question on the new 485. Should I send unsolicited financial info or wait for the RFE? Wait for the RFE. If you send in this unsolicited financial information, they're just going to throw it away. They don't know what to do with that. Wait for the RFE. I can tell you if it's the question I think it is. This was actually on a listserv today that asks if you are subject to the public charge rule. The answer for most people applying for employment-based is yes. That doesn't mean you are a public charge. It's just, are you subject to the rule? I don't think you're going to jeopardize your 485 if it's that question, but just wait for the RFE if they take or the interview, and you should be fine.
Prashant's I-140 has not been withdrawn for more than 180 days, but his employer is not providing the I-140 approval. Can he file for the H4 plus EAD? If you have a receipt number, though, you can use that and go to online and print out an online I-140 approval, and then you can use that as an I-140 approval to apply for the H4 EAD. The other way around to get your I-140 petition copy is you can file a Freedom of Information. It's called FOIA USCIS. You can fill it out online. It will take about 6 weeks for you to get an I-140 approval copy. And based on that, you can still file for the H4 EAD.
Question from Ram on YouTube. I'm currently in the U.S. on an I-140 EB2 for a tech lead role. Do I qualify for an EB1C? Do I need to be a manager in the U.S. and then outside the U.S. as well? So kind of backwards, Ram. In order to qualify for an EB1C, you have to work for a qualifying entity in a managerial role for 1 year. And then the future job on the green card has to be in a managerial role as well. Obviously, there has to be the qualifying relationship between the two entities.
Jayesh Nair has this question. I have an H1B EB2 priority date is March 2022. If I become a Canadian PR and later on become a Canadian citizen, am I in future eligible for TN visa? Assuming that you have an EB2 I-140 approval, though, it becomes a hindrance for you to get the TN visa. Because for the TN visa, your intention should be only to temporarily come into the United States and work and go. But since you have an I-140 approval, you have expressed yourself that you want to stay here permanently. So under the circumstances, even if you become a Canadian citizen, though, I would still recommend to use the H1B because you have an I-140 approval. Most probably you have been already counted toward the H1B number, so you don't need to go through the H1B lottery. So why not use the H1B instead of TN? That would be your greater advantage instead of moving into TN visa.
Question from YouTube. I'm an L2 spouse. Do I need an EAD to work in the U.S.? Nope. This is a lawsuit we settled a year and a half ago, 2 years ago. I don't know. L2 spouses are authorized to work incident to status. So as long as you have that L2 I-94 that's valid, you can continue to work in the U.S. You don't need an EAD.
Prashant, you're right. It is the online case status of the USCIS that we have used to file for an I-140, use that as an I-140 approval for the H4 EAD. We didn't had any issues with it. Steven has already answered about the third H1B lottery. We may still be expecting, and maybe not. We don't know. Most probably, we should be getting it soon. If we don't get it by end of this year, most probably that will be over. There will not be any lottery. That's my expectation.
Yeah, they're getting kind of late on it when you consider the 90-day filing window. They're getting really late to make a decision. Question from YouTube. My end client has changed in the same city, but I'm working remotely from home, which is already mentioned on my H1B or on the LCA. I don't have an H1B visa till now. Do I need to file an amendment before stamping? Maybe, and I hate to give that answer. The consulates don't follow the same rule that USCIS uses. If the only address on your LCA is your home address, then I don't think you do. If you had the client location and the home address, I would maybe consider filing an amendment just to be safe.
I'm going first time for the H1B stamping. Currently an F1 visa. Do I qualify for the visa waiver interview right now? I have an F1 stamping in my visa. Neha, the rules say that you don't need to go for stamp. You may be eligible for Dropbox if you go by December 31st of 2023. Starting from January 1st of 2024, we don't know at this point of time you'll be eligible for the Dropbox. But as of December 31st, you are eligible for the Dropbox.
Question from YouTube. In March 2023, USCIS clarified that H1B folks who lost their job can file a change of status to B1, B2, and continue to search for jobs if does this change? Does that change if you have an I-140? And the answer is no. So in the guidance that they put out for non-immigrant workers, so H's and L's, TNs, they actually specifically address this if you can file a change of status to B1 or B2 if you have a pending or approved I-140, and they say yes. So long as you maintain an intent to depart after the approved B visa and continue to maintain a resident abroad that you don't abandon, it shouldn't have any issues. We've done a few of these cases. I haven't had the issue pop up at all. I print out the policy and go with it.
Kiran got an RFE to submit the medicals for the 485 application. His EAD and AP is approved. What will happen next? Kiran, if your priority date is not current, though, they are not going to give you the green card. They will just take the medicals and do nothing. But if your priority date is current, final action date is current, of course, there's a chance that you may get the green card sooner, which is a good thing.
A question from YouTube is about the compelling circumstances EAD. As people are losing their jobs, given the kind of the current financial climate, any thoughts on that? So, the compelling circumstances EAD, I think, is a really good tool. My personal opinion with this March guidance about the B visa option for those that were terminated, I think it's a little bit better of an option, and here's why. One, the compelling circumstances EAD is taking a long time to get approved. And if it is approved, it's not status. And what that means is if it is approved, you can work, but you can't change your status to back to H1B. You would have to consular process. With the B visa guidance that they have, you could do the B visa, and then if you get a job offer, you can do a change of status back to H1B in premium, and they'll adjudicate it together. And that's typically a quicker turnaround than waiting for the compelling circumstances EAD, which I think when we were doing a bunch of those was about a year. So just there's pros and cons to both. I just personally think the B visa is a little bit better right now.
Question is that in March of 2023, USA has clarified for the H1B folks that they can move on to the B1, B2. Waiting for, looking for another job, they can move on to the B1, B2. But if their I-140 is approved, do you see any problems in getting the B1, B2 approved? This question comes from Ramba MKI from YouTube. The answer is we haven't seen any problems in people who have an I-140 approval in getting the B2. Absolutely, we have not seen any problem. Even though people have an I-140 approval, we have seen their B1, B2s getting approval. And those people who applied for the B1, B2, even when the B1, B2 is pending, if they get a job, they have applied for the H1B, and their change of status from B1, B2 to H1B has been approved without any problem, without them going outside the country and getting stamping. They were able to change the status within the United States.
Question from YouTube: how long does it take to get an I-485 approved after responding to the public charge RFE? I-140 is approved. 485 in January 23 will become current in January 24. It just depends. Each field office is kind of unique. I don't think there's a specific timing for it, but I would keep reaching out to them and kind of push for them to make a decision.
Dhruv tried to book his appointment for November 2023, got his appointment in January 2024. Will the Dropbox be available for him if they don't extend the rules right now? We don't know yet, Dhruv. We don't know yet. Starting from January, will they accept the rules that they have done it in the COVID period of time? For example, if you're moving from F1 to H1, you're eligible for Dropbox. Right now, will you be eligible starting in January of 2024? We don't know yet. We don't know yet. We will come to know, and we will update you in January first week and second week about that. But as of now, we don't know.
Bhavan asks a good question here on Facebook. Can an EB3 with a September 2020 priority date be upgraded to EB1? Yeah. So EB1, 2, and 3, you can upgrade, downgrade between EB1, EB2, EB3 all you want. Obviously, you have to get the EB1 I140 approved before you upgrade to EB1. But yeah, no issue with that at all. That's something we've been doing a lot of as people are kind of exploring that route.
How
EB5 is
long?
the only one you can't port.
How long is the H1B extension taking nowadays? Anywhere between 2 weeks to about 7 months is the time it's taking for the extension of status for EB1B. Oh, sorry, for the H1B.
Question here from Rahul on YouTube. I saw the update on my USCIS app. Request for initial evidence was sent to me today. This is from my EB3 485, which was filed in December 2021. Probably a medical RFE is my guess.
Yeah, initial evidence normally could be medical, Stephen.
Yeah. So keep an eye, respond quickly, and then consider suing on the delay if it's current.
Can we file EB? Sorry, I'm sorry, guys. Sorry.
Yeah, this is a good question. Um, we have both EB2 and EB3 with EAD and AP. Can we renew only one or both? You can renew both. There's with the 5-year approval periods right now, I don't think it's much of a reason to do both. I would maybe pick one, but if you have two 485s, there's nothing that prevents it.
Any truth behind Indian media circulating that they're increasing the H1B fees by 70% along with other petition fees? We have seen that the consulates in India were supposed to do the fee increase, but at this point of time, they put a pause. That is true. They're not increasing the fees for the visas that people apply in the U.S. consulates in India.
Question on YouTube. I'm checking if there's any way premium processing available for H4 EAD, as I filed change of status for my dependent from H1 to H4 and H4 EAD. If it was filed separately, no. If it is filed concurrently with an H1B and the H1B is filed in premium, they're supposed to do it all together.
Can we travel on advance parole if the H1B extension is pending and in progress? Absolutely not a problem. While the H1B extension is pending, if you want to travel on advance parole, you will have no problem, none whatsoever at all for you to travel outside the country and come back in.
Question on YouTube. Priority date is December 2014 in EB3. I downgraded from EB2 in 2020. Got a medical RFE and submitted. Current status shows visa's not available. What happens next? This is actually a really common thing. I don't know why they're asking for medical RFEs when people aren't current, but they are. Unfortunately, you have to respond. Otherwise, you might abandon the 485. So unfortunately, you just got to wait.
Yeah, don't try to fiddle around with them. If they're asking for the RFE for medical, please provide them with the medical. If you don't, they may deny your entire 485 application.
Question on YouTube. What's the criteria for filing litigation on I-131 processing times? I'm looking for cases that are at least 4 months, I think is a little ridiculous. If there's extenuating circumstances, I'm happy to talk about maybe being a little bit more aggressive, but 3 to 4 months usually is about where we want to be at. There's some good arguments as why I think 4 months is about right.
Yeah, the people are asking about why China dates are moving. Well, the demand from China is less, I guess, from when compared to the Indian nationals. That's the reason we have seen some improvement in the Chinese nationals, EB1, EB2, and EB3 respectively. We don't know if the trend will continue on it, but for sure seems to be that for Indian nationals, the backlog is going to be very significant, and we are not expecting significant movement in the EB2 or EB3, at least not in this financial year.
Question from Abby on YouTube. I got promoted last year, but hadn't filed a new LCA. Any impact on future extensions? Whether you have to file an amendment isn't just based off the promotion. It's a question of whether there's a material change. If you're still doing the same jobs and maybe they gave you a little bit of a raise, an amendment might not have been needed. It's going to be a very fact-dependent question on that. Honestly, your worst case scenario is, I think, if they say you should have filed an amendment, is they would deny the I-94 and you'd have to go for stamping, but I don't think it's going to have any long-term impact.
Rahul, his daughter has filed in advance parole in January 2023, though. No update is this normal time. We're noticing advance parole, particularly anywhere ranging between 2 months to even 16 months of delay in getting the advance parole approved. Now, when it comes to the EAD, though, it's only anywhere between 2 months to 6 months. But when it comes to advance parole, anywhere between 2 months to about 16 months. The good part right now is that we're noticing the EAD or advance parole approvals only for 5 years, which is very good news for us. Since the time of November of 2023, I haven't seen any advance parole or EAD shorter than 5 years.
Hopes for a third lottery, Paul. I don't know. It's hard. We got to wait for the announcement from USCIS one way or the other.
Abhi, how many applications can we file for I-131 if we are not getting an update? There's no limit for it. If they will see that they already approved you an advance parole, at the most, they will deny your subsequent advance parole, but I don't see any negative consequences going forward for you.
A follow-up question about the I-131. What can be done to get started with litigation? Shoot me an email, Steven, STEVEN, at rnlawgroup.com. We'll get together. Let's chat about litigation and get you going on that.
If someone is a Canadian citizen and approved H4 EAD, are they allowed to work 2 jobs, one in US and one in Canada, remotely in Canada? Ajit, this question is coming. Ajit, I can only speak about the H4 EAD here in the United States. So now, if you are here in the United States, you are on H4 EAD, you have a work permit to work. You can work for multiple employers. One employer here, one employer you can work remotely in Canada. You don't have to be a Canadian citizen. The rules of Canada, the rules of India, the rules of United States, right now though, we only recognize a but rule. Wherever your but is sitting, you must have a work authorization. Since your but is sitting in United States, you have an H4 EAD, which is very unrestricted H4 EAD, because unlike H1B, there is no restrictions on the H4 EAD. You can do multiple jobs, and I don't see any problem in you doing it. Question is coming from Visa Fall, Stephen. Now, there are a lot of people who want, Stephen, are you there?
Yeah, I'm here. Yes.
Stephen, what is the process of litigating for the advance parole delay? What is the timeline and how much is the cost involved in it?
Yeah, so the big thing is I'm looking for at least 4 months. Typically, that'll put us about 6 months pending by the time the government has to respond. They have 60 days to respond from the time that they're served with the lawsuit. We're doing these as individual litigation, so our cost is a little bit higher than when we used to do the H4 EAD cases in groups, because we are having to do these as individual. Why are we doing these on individual? Because the government kept fighting us procedurally on grouping cases together. And I'd rather fight, if they want to fight on a case, I want to fight on the merits, not on some procedural grounds. And so some of the courts have made it tougher to file group cases. Some still take it. I just don't want to get stuck in giving the government that option. So we're doing delay cases for the most part as individual outside of a couple instances. So shoot me an email. Happy to set up a call with you so we can talk about the litigation option. Shoot me the details. Set up a call with you. Don't charge for that call so we can talk, figure it out. Maybe litigation's not right for you. Maybe it is right for you, but I want you to kind of know the pros and cons of it, and then let's get to it.
Question from Vinayak, and these kind of questions are coming very frequently, that while they are in the 6th year of H1B, while their PEM is getting processed, they get laid off from the company. What are the options available? Well, you can try to find a company that can file a green card for you, even if you're not working for that company. You can try to find a company that will continue filing with your green card process even after you leave the country, or even if you move to B2, or even if you move to the H4 option, you can find a company that can file a green card. I normally request people to have a consultation with an immigration lawyer. If you have been in this country for more than 4 years on H1B, and if your labor certification is not yet approved, this is the right time for you to make a way where you need to look into alternative options. If the current company that you're working, if that company doesn't get you the labor and I-140 approval, What is the alternative? You need to think right now. Don't call me five years, 11 months, and 28 days and ask me, Rahul, what can I do at that point of time? Because it's easier to find a solution right now when you are in the fourth year of your H1B rather than 5 years, 11 months, and 28 days. That's not
Yeah.
a good time to contact me.
Yeah, but I know it's stressful, and that whole situation sucks, and I'm sorry to hear that. But the good thing is, from an immigration side, it's not the worst scenario to be in. You have time to start the perm process, get everything good before that September 2025 deadline. Abby from YouTube is trying to make me look good here, Rahul. Abby's asking if we've got a WhatsApp channel so we can get updates on a regular basis. Already subscribed to the newsletter. Not on what so I have WhatsApp. Rahul has WhatsApp. We do have a Telegram channel. I don't have the link right now, but if you shoot me an email or shoot our info at our law group, we can get it to you. We do have a Telegram channel. Recommend you guys join it. We kind of do it as an extension of Rahul's daily conference call. If you have questions that we can answer, without a lot of digging into that might require more time one-on-one, happy to do it on there as well as provide updates.
So don't forget that we do have a daily Zoom call, guys. Every single day from 2012 onwards to right now, from past 11 years, we're doing a daily Zoom call. It used to be conference call and Zoom, right now it's Zoom call. Every single day we have a conference call for half an hour. The timings are provided at the link at the bottom of this video. You can come and join and ask the questions there. Anything else, Stephen?
No, just like Rahul said, be sure to subscribe. We try to keep updates going on our Twitter, YouTube, Telegram, Facebook, newsletter. Subscribe. We try to be very accessible to provide updates on information. If there is a third lottery, all you guys asking about it, we will be quick. Whether it's Emily Newman's Twitter, our firm Twitter, my Twitter, we will be sure to get an update out there as soon as we get those emails.
Anything else, Stephen, before we close?
No, I'm good.
Thank you, Stephen, for joining. Thank you, everybody, for joining. We'll see you next week at the same time, 5 p.m. Central Time, every Tuesday, live updates and live question and answers. Thank you very much.
Thank you.